Good morning. Before we call the first case, a reminder to everyone arguing, counsel or pro se, that it is being live streamed today, so keep that in mind. If you have a case that involves children, particularly, try to be a little cautious and judicious in what you say, and to the extent you can. That's your argument, but certainly as far as names and items like that. Call the first case, please.
Danny Ray Franks et al. Versus Roger Bibrey et al.
We'll hear from the appellant.
Morning, Your Honors. I'm Bradford Wood from the law firm of Cameron, Goolsby & Gross in Putnam County, Tennessee. I'm joined by Mr. Nolan Goolsby, my boss and mentor. He did the trial in this case, and I got stuck with the appellate work. So this is my first time in front of you all, so I'm a little nervous, but I think we will be able to get it done.
Did Mr. Goolsby take that approach that you had to argue? Yes.
It was about this time last year, I think. Hey, I need you to do the appeal. Yes, sir.
Okay.
So I got it done.
Seniority has its privileges.
It does, yes. I'd like to reserve 5 minutes for rebuttal argument, Your Honors.
That'll be fine.
So I'm here for Roger Bibrey and Bibrey Construction, the appellants. Basically, the reason we're appealing this decision is, as much as I respect the chancellor in Putnam County, we believe he got the law wrong. The chancellor found that the contract was breached in Thanksgiving of 2018. This is a construction contract. There was no time of the essence clause in the contract. Case law tells us that in a construction contract, you're not going to be liable for a material breach if you don't get it in the completed for time. So when my client failed to complete the construction work in Thanksgiving of 2018, we don't believe it was a breach at all because the appellees consented to the work for several months. They stayed in contact and continued to work with each other. And eventually they fired him around April of 2019, citing that you didn't get it done in Thanksgiving of 2018. So
Well, it did have a provision to say that Thanksgiving was a completion date.
it was, but our argument is that that's just the normal, a normal time for completion. It's not a time is of the essence. There's no actual provision in the contract that says times of the essence.
Could you read the trial court's order as finding other defaults in addition to untimeliness? I mean, the trial court goes on to mention some other concerns about the quality of the work that had been performed. And I think perhaps it's a fair reading that the court also found additional defaults in addition to not completing by the Thanksgiving date.
He does, and he goes on to, I believe, say that my client, was a little slow to get started, and there were reasons for that. But he does say that the breach occurred Thanksgiving of 2018. Start immediately, completed by Thanksgiving is what he focuses on. His main point for the breach is that it was not completed by Thanksgiving of 2018. So we argue that that's not a material breach and that the appellees consented this work. They continued to work until April at least. There were reasons that the work was continued to be slow. The appellees wanted concrete poured instead of gravel. They took forever to get the materials they needed. I believe it was March to get flooring materials. They hired a new contractor to lay the floor in April. He didn't complete the work until May. And the appellee even admits that my client couldn't finish the job until the floor was complete. Well, one day they finally text him and say, don't come back. He can't complete it, has no time to cure. So we argue that's when the breach happens.
Let me ask you, counsel. I mean, the contract, in addition to having the completion date by Thanksgiving, it also had a provision start immediately.
It does.
Did your client start immediately?
I'm not really sure. I wasn't at the trial for that, but I don't think that. I think he did begin to start, but he might not have done, all the work. But he did start around the May time, I think.
Do those two things taken together, the start immediately, complete by Thanksgiving, does that make this different from? Oh shoot, I can't think of the name of the case you all rely on. That.
Madden Phillips.
my brain has left me, where the trial court, where the
Sure.
appellate court
I
found
still,
that there
I don't
was
think
no.
so. I think that it's, I mean, it's start in May, end by Thanksgiving. That's just a general time. There's reasons that he couldn't get it finished in that time.
How long did he have? I mean,
Well,
does
if
there, let's assume, purpose of this question, that there's no time is of the essence. Assume that.
Yes, sir.
Does that mean that, it can go on forever?
I think it can go on as long as reasonably necessary. So
So it could be a year,
it
2 years,
could be
3
2
years?
years. I think so. Whatever's reasonably necessary to complete the work. Now, he's supposed to start in May, supposedly end by Thanksgiving. He can't get it done in between that time. The appellees are okay with that. And there's reasons they hadn't sold their house. They needed money to pay him. He couldn't get the materials he needed. So there's a lot of reasons why he wasn't finished by Thanksgiving that aren't just his fault. So a reasonable time, I would think, he couldn't get it finished at least until May of 2019, because that's when the flooring was finally complete. So if you look at a reasonable time, it could go 2-3 years. I mean, depending on, they're contractually obligated to pay for materials as justified and needed. They're not able to do that. They don't sell their house until January of 2019, and they needed that money to pay my client to buy the materials. So there's no way it could have been finished in the contractual time, and reasonableness, I would think, could go as long as it needs to. But with that said, they did not order the materials that they needed. They waited until March to do that. They wanted concrete. There was rain issues that caused the concrete not to be able to be poured. The flooring doesn't begin until April, not finished till May. And most importantly, they didn't pay for the materials, so my client can't finish it. So that would be our argument, that there are reasons that this wasn't completed. Once they fired him, he has no opportunity to cure. They cut it off and say, "You're fired. You're going to hear from our lawyer," which is exactly what happened. My client's not able to finish the work.
If the breach is failure to timely complete the contract, how can given additional time allow him to cure the breach?
Well, I don't think the breach is. It's not a material breach for him not to complete in November of 2018. That's just.
Well, let's assume that
Okay.
it is. As I
Okay,
understood,
well,
your
then
argument was that
then they should have fired him in
They fired him,
November.
didn't give him a chance to complete the contract. Well, if the breach,
Then they should have fired him in November of 2018.
Let me finish.
I'm sorry, Your Honor.
That's okay. If the breach is a failure to timely complete under the contract, and you say, well, they didn't give him an opportunity to cure the breach, he really couldn't cure the breach, could he?
I guess not, but they should fire him in November of 2018 if that's the case, and they don't do that. They say it's okay. We don't have our house sold yet. So, I mean, if they're going to rely on that, they need to fire him in November of 2018, not wait until April or May of 2019 to fire him. And so, with that, I yield the rest of my time. That'd be our argument, Your Honor.
You have your time for rebuttal.
Thank you, Your Honor.
Here from the appellee.
May it please the court. Good morning. My name is Matthew McClanahan with the Cumberland County Bar, and I rise on behalf of the Franks this morning. Your Honor, if I may have just a brief recitation of the facts, just so to give you some more context for our case. This case revolves around a barn dominium, which is in some ways all things old or new again. If you are a student of history here in the state of Tennessee, you know that some of the early pioneers, they would build the barn first, and then they would build the cabin, and they would live above the barn or the structure that they would house their livestock in, and sort of a similar type situation that has occurred here. Now, my client's contracted for the construction of a barn dominium in rural Middle Tennessee. It's a large area, has a large storage facility below it, and that they would live above that storage facility in a dormer in that process. Relevant because it is a different type of time span that would be appropriate for the construction of this type of building, this barn dominium. Again, they entered into this contract in May of 2018 for the construction of this barn dominium. My clients were residents of the state of Texas at the time, and Mr. Bibrey himself drafted this contract. Now, the contract, Your Honors, is not one that an attorney would draft, and unfortunately, Mr. Bibrey proved as poor of a contractor as he did a contract draftsman, but this court should draw all reasonable inferences against the maker of that contract. To wit, Mr. Bibrey wrote, "Start immediately, completed by Thanksgiving of 2018. Those words, "start immediately," give a sense of urgency to this contract that the trial court judge, Chancellor Thurman, read as interpreting this idea of time being of the essence. Moreover, the completion date, completed by Thanksgiving of 2018, has further importance with the understanding that my clients were moving to the state of Tennessee from Texas, and they wanted to celebrate Thanksgiving with their family in their new Tennessee mountain home. Unfortunately, the home was not completed by Thanksgiving of 2018, nor was it completed by Christmas of 2018, or New Year's, or Easter of 2019 for that matter. And finally, with my client's patience wearing thin, they terminated Mr. Bibrey, and the proceedings that we have discussed earlier resulted from that. As this court has alluded to, this idea that the Madden case has this approach to reading time of the essence in a construction contract, that, quoting from Madden Phillips construction, which both sides utilize, time is of the essence can be shown by a stipulation, a manifestation of intention from the contract or the subject matter involved, or an implication from the nature of the contract or circumstances of the case. There's a case right here in Davidson County, Alexander and Schenkel versus Metro. This case is unreported, but it states that a failure to meet a time-specific and explicit time requirement constitutes a breach, even in a construction contract.
Did you cite that case in your brief?
The Alexander and Schenkel Metro case, I did not cite that in my brief.
Would just send a letter to the court clerk, copy to your opponent, and just give us the side on the case. Don't argue it. Just give us the side of the case.
I'll be glad to, Your Honor. Yes, Your Honor. So in the case that we have here at bar, the factual findings that the chancellor reviewed, again, when we look at this burden that this court takes upon itself, this idea that the factual findings, my clients are to be given the benefit of the doubt, that the appellant bears that burden of showing that the factual findings that Chancellor Furman made were in error. As we look through the record of this case, and as we see what occurred there, we find that Chancellor Thurman, in his final order, cited that he did not find Mr. Bibrey to be a credible witness for a number of different reasons. Now, while the breach of a contract or not is a question of law, the determination of whether a breach has occurred is a question of fact. And the factual determination on a trial judge's assessment of witness credibility receives an even higher degree of deference to the trial court.
Are you conceding for the purposes of your argument that the only breach that the trial court relied on here is the failure to complete by Thanksgiving of 2018?
I would not, Your Honor. I would state that throughout the proceedings that Chancellor Thurman saw repeatedly from multiple witnesses evidence that Mr. Bibrey also failed to perform the work in a workmanlike manner that met his duty to my clients. And because of that, they had to then go in and hire additional contractors to remedy the mistakes that he made. And he makes allusions to that in his final order as well.
And then going back to your argument about the credibility, the importance of credibility determination here, what bearing does credibility have on contractor's credibility here have on the issue of whether or not time truly was of the essence of the contract, and if it was completed by Thanksgiving of 2018? Everybody seemed to concede that it was not completed by then. So I don't know that credibility really amounts to much in this case.
It matters in this way, Your Honor. Credibility matters because some of the excuses that he provided for not finishing the job within that time frame, he gave basically 3 different stories throughout the proceedings. One version that he said, well, I wasn't able to start immediately because I needed some more funds, and I was just covered up. I was just so busy, I just couldn't start immediately. Then he also gave a version of events that, well, I wasn't really working on any other jobs. And finally, through additional testimony, it was revealed that he was actually working on his son's house as well. What the truth is up for debate. So it matters to the extent that why the house wasn't finished, and it goes to this idea of time was of the essence for my clients. They wanted to move to the state of Tennessee so that they could celebrate the holidays in their new home. And the damages that naturally flowed from that breach were evidenced by the court in its ruling as well. They had to hire a plumber, an electrician, a carpenter, someone to complete the HVAC. The damages totaled over $32,000. My clients are simply seeking what they originally contracted for on that very meager contract that Mr. Bibrey drafted. That being that they wanted, to the benefit of their bargain, that they simply wanted a home that was completed and a barn dominium with the time that was specified.
To what extent did the trial court take into consideration the delays that your client caused? For example, the concrete.
I was not the attorney of record
Well,
at
we
the trial
weren't there
proceeding.
either.
However, I'm sorry,
We weren't there either, but you and your opposing counsel have a duty to read the record.
Yes, Your Honor. Yes.
Before you get up here, so that saying that you weren't trial counsel is not an excuse.
No, I understand, Your Honor. It is my understanding from that the trial court basically saw the concrete issue as the principal matter that was dissolved there. He did not put any bearance on my clients from that. It was, the concrete issue was sort of the way he terms it in his order is a he said, she said type issue. And my clients ultimately decided they were going to go with another floor to help expedite matters, to help get things moving. So they decided that they would go with another type of flooring, Your Honor. Again, my clients are simply looking for this case to be upheld. We believe that the trial court entered a proper judgment against Mr. Bibrey, and we would ask that this court affirm that decision. Okay. That concludes my time, Your Honors. Appreciate your attention.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Your Honors, my friend Mr. McClanahan mentions that they wanted this completed by Thanksgiving of 2018, which is what the contract says. But they had not even sold their house until January. They couldn't have celebrated Thanksgiving there. They still had their house. They needed the money to pay my client. Time is of the essence for them to pay my client the money that they've contracted for that's in there, and they don't have the money to do that. They didn't pay on time. He can't get the work completed if he doesn't have the money to buy the materials.
Well, what do you do then with the trial court's credibility determination as to your client?
Your Honors, I don't believe credibility really matters in a question of law of whether time is of the essence. However,
Well, I understand that, but as to your client's testimony, I couldn't do this because I was covered up with work. I was working on my son's home, and I mean, what do we do with the trial court's determination as to those factual aspects that your client testified to?
well, if you're looking at credibility, I know Miss Frank says that she had numerous text messages from my clients saying that he was going to quit the job. Well, when Mr. Goolsby asked her about that, she can't find the text messages. She doesn't have them with her, even though she documents everything. The trial attorney said, well, we've done discovery, we've submitted everything, and these text messages aren't there. So I think that goes to her credibility, that maybe this credibility determination was a little wrong. We've got numerous texts and emails saying that it's okay for my client to continue working past November of 2018 because we haven't sold our house, we don't have the money, it's okay. So time really is not of the essence here, and they're waiving any breach. If they want to fire this man, they need to do it November of 2018 instead of waiting until April or May and then complaining, oh, you didn't get it done in November of 2018. And the change in the flooring obviously slowed delays, and they were responsible for many of these delays. So there's just no possible way he can get it done on time with the money and the delays that they have caused. And firing him for something that happened in November of 2018 is unreasonable. And with that, I'll waive the rest of my time, Your Honor. Thank you.
Court's thanks to counsel for both sides. We appreciate your briefs and your arguments this morning. Thank you.